Supreme Court refuses to revisit parental consent abortion law. Montana's legal battle extended. In a bold move that has continued to echo throughout legal and social circles, the Supreme Court decided on Thursday not to take up the challenge of a Montana statute mandating that individuals under 18 must obtain parental consent before an abortion. This pivotal choice preserves the authority of a prior state court decision that invalidated the old law. Montana's 2013 legislation sought to prevent doctors from performing abortions on minors without a notarized consent from the parent. However, the highest court in the state determined that this law breached the Montana state constitution, offering more extensive abortion protections compared to the U.S. Constitution. Though the Supreme Court didn't elaborate on its choice, Justices Samuel Alito and Clarence Thomas issued a brief statement indicating that the case's procedural issues made it unsuitable for evaluating the legitimacy of such regulations. They pointed out that their refusal to hear the appeal should not be interpreted as a dismissal of the arguments presented. The state of Montana contended that parental authority should encompass all medical decisions related to their children, as parents are typically assumed to act in their child's best interests. The state argued that its intervention should be minimal unless the parent is deemed unfit. On the other side, Planned Parenthood emphasized that the legal debate centers primarily around Montana's state constitution's stance on abortion rights. They pointed out that the argument from Montana officials assumes that parental rights are the only consideration, neglecting the broader implications of constitutional protections. The Montana statute, which never took effect, stipulated severe penalties, both fines and jail time, for physicians who carried out an abortion without the required parental consent. It provided a legal pathway for minors who could demonstrate their maturity and awareness by persuading a court to let them make the decision independently. In a historical context, the Supreme Court had earlier ruled on related cases, such as in 1976 in Planned Parenthood of Central Missouri versus Danforth. During this and other landmark rulings, the court invalidated consent requirements, emphasizing the importance of the constitutional right to abortion. With the recent shift following the Supreme Court's decision in Dobbs versus Jackson Women's Health Organization that overturned Roe, Montana argued that its justification for the law grew stronger, as it aligned closely with state-level interpretations. Montana emphasized that state courts' conclusions on abortion rights challenge fundamental principles of parental rights. So, what do you think about the balance between parental rights and minor autonomy in medical decisions? Share your thoughts. Should parental consent always be a prerequisite for medical decisions involving minors?